Full, in-depth, 360 understanding of the story. Make sure to check it out. All right, I want to talk about this. A lot of different moving parts to what we can expect today. So, I am joined right now by Law&Crime's attorney, their general counsel, Elizabeth Vulai. Not here to make sure that we're not in trouble. We never get in trouble, right? No, but she's been following the case. We love having her on. And we are also joined by criminal defense attorney Nima Rahmani. Thank you so much. She's a former federal prosecutor as well. So happy to have you both here. Nima, I will start with you. The big issue, I think it's going to come up, is prosecutors. Why shouldn't Combs be released if Mike Jeffries is released? And they responded in a filing. We'll get to it, but what do you think?
Well, two very different cases, Jesse. And obviously, when we're talking about sex trafficking, you're talking about force, fraud, or coercion. And in Combs's case, we're talking about a lot of force. Now, Jeffries, there was an alleged fraud. The victims were told one thing, they'd be models, and next thing you know, they're participating in these sex acts. There was some allegations of force, maybe some security didn't let them leave, but there's no video of Jeffries beating anyone. And the sheer number of victims that we have, I know obviously there's only one in this indictment so far, but many have filed civil lawsuits. So in my opinion, two very different cases. And you know what? People lie, defense attorneys lie, defendants lie all the time, but video doesn't lie. And I think if Onion looks at that video that CNN got in May from that 2016 beating, less than a mile from where I'm sitting right now, that is not someone that is going to be safe if released. He's a danger to the community.
Defense would say that's 8.5 years ago. Should that be definitive proof that he's a danger to others on the outside? I want to give everybody an update, and then Elizabeth, I'm going to go to you. As I said, we'll provide you updates from court. Sean Combs' attorney, Tony Rico, has come back into the gallery to speak with Sean Diddy Combs' supporters. So apparently there might be supporters in that courtroom. We'll get a better understanding when Elizabeth Milner comes out to us later. And Alexandra Shapiro, who is another one of Combs' defense attorneys, is sitting reading from a binder in that courtroom. 4 prosecutors are in the front row. Sean Combs has been brought in. He is wearing the MDC jail tan uniform that we've described before. You probably see it in kind of these courtroom sketches. And he has hugged his lawyer, Mark Agnifilo, and then sits chatting with his other attorney, Mr. Rico. Okay, so Elizabeth, let me go to you about this. The government has said with Mike Jeffries, he wasn't charged with racketeering. He's 80 years old. Sean Combs is 55 years old. There are efforts by Sean Combs to try to obstruct this investigation, reaching out to witnesses and victims, including behind bars. And there's not, but again, on the other hand, Mike Jeffries is charged with sex trafficking using force, fraud, or coercion, very similar to Sean Combs, but they say that this is superficial similarities and it's two completely different cases. What do you think?
Yeah, I think so as well. Obviously, there's a little bit of overlap there. They've both been indicted for sex trafficking charges in federal court in New York. They're both high public profile figures. So there's some overlap, but I think also one of the biggest key differences is that so far with the Jeffries case, we haven't seen any allegations of possible witness tampering, any obstruction of justice. I think that's going to be a big part of what the prosecution is going to try to argue. And it was also layered into the hearing that happened earlier this week with all of the notes that were seized as well.
Nima, we're getting some questions from our viewers, so I want to read them. Again, submit them on YouTube. The question that we first have is from Sandy Rivera, who, by the way, Sandy, thank you so much. I know that you always comment on YouTube. We really appreciate it. The question for Nima is, why did he request no restraints at this hearing? Just to put a little clarification on that, he had actually petitioned to not be in restraints, not only for this hearing, but the last hearing, and presumably for the hearings moving forward. It's interesting considering there's no jury yet, so why request no restraints?
Well, it's a typical request that defense attorneys raise, and certainly you don't want him to be restrained if you're his lawyers before the jury. That can be prejudicial. But right now, to the extent that he has been nonviolent in prison, nonviolent in court, that's something that the U.S. Marshals can certainly handle Sean Diddy Combs without restraints.
Question for you, Elizabeth. This is from Fishlock47 on YouTube. Are any celebrities expected to testify? Well, I don't think today. The question becomes, will they be testify at an upcoming trial, which is currently scheduled for May of 2025?
Yeah, I don't think we're going to see any celebrities today. I think today is going to be strictly about, his bail hearing. What are the reasons that advocate that he be kept in prison until the trial, whatnot. But I would be shocked if there's no celebrities coming forward ultimately at his trial. Again, we've talked about this is someone who's had relationships with celebrities, friendships, business relationships for decades. He's been in the business forever. There's going to be people who have relevant information here.
Nima, question for you. This is my question. So in anticipation of this hearing, Sean Combs, I'm going to turn it this way. Sean Combs' defense counsel filed something very interesting with the court. They filed this is what they write the court. They write Judge Subramanian. In support of Mr. Combs' renewed bail application, we have submitted to the court and the government a 20-minute video under seal. And we don't know what that video is, but they said the video was prepared by Connor McCourt, who was previously a foot patrol officer with the New York City Police Department. He was promoted to sergeant. He was assigned to the Technical Assistant Response Unit. Why do I feel this has to be about Cassandra Ventura? I say that because it seems that a big factor, a big point of discussion in this bail analysis, and there's been briefs back and forth, has been whether or not she is credible, whether or not her description of this relationship was, for example, the 2016 video of her trying to escape a freak-off wasn't an example of sex trafficking, or as the defense would say, we'll show you text messages, we'll show you other evidence that this is just a really toxic relationship. It's not evidence of sex trafficking or racketeering. It can't be used to justify detention. Would I be so far off to say that this 20-minute video under seal might have to do with her?
I think that's a good guess, Jesse, and we can guess that because the defense has said that this video is edited. It doesn't show the full story. It's a snapshot in time. I don't know what more we need to see, even if the relationship was toxic, tumultuous. Let's not forget, it was Cassie Ventura's bombshell lawsuit in November that really started all this. And the other victims who have come forward have told very similar stories of physical and sexual violence. So even if Cassie, Diddy's longtime girlfriend of more than a decade, is lying, even if you don't believe her, I mean, there are dozens of other victims who are telling the same story. It's going to be hard to disbelieve everyone.
Want to give everybody an update in court. Sean Combs and his lawyers, they're sitting at the middle of three tables. There are two
This is about to
US
get very
Marshals,
interesting.
who are there as well, and they're, rather than directly behind him, as is usually the case, they are on his sides. Nima, I'll just go back to you. Is there some sort of security risk that we should be thinking about here?
I don't think so. I mean, Diddy could have taken off, and we're talking about bail. You're really looking at two issues: risk of flight and danger to the community. I don't think he's going to try anything because that's a surefire way to be shackled the rest of the trial, and he's not that stupid.
Okay, well, in all fairness, let me just say he's also accused of reaching out to witnesses and victims through his family. When that became a central issue of why he's been denied bail, if that's true, if the prosecutors can prove that to the court, that's not great. That would not be the most reasonable thing. We'll get to that in a second. We have a question from YouTube here. I actually think he probably has the better shot making bail in front of this judge right now, because the judge seems at least open to some of the arguments put forward by the defense. We'll see if it works.
Yeah, at least the judge's hearing them
question
out this time to go around.
This is from Dr. Firewater on YouTube. Seems like a contradiction, Firewater, but anyway.
Interesting name.
Will Diddy's life be put in jeopardy if he's released on bail? Public outrage or celebrity hit job? Is it safer to keep him incarcerated until cleared?
I think that's highly doubtful. I mean, in the case of Mike Jeffries, he was able to be released on bail. He's under home confinement. He's being monitored. You know, someone like Diddy, who has not just homes, but really estates with security. If he's confined to his home, I would imagine that's probably safer than most prisons within New York.
More people are talking about Diddy than they are Mike Jeffries. And more people, the argument would be, are concerned about being wrapped up in Sean Diddy Combs' allegations or anything like that.
It is true. It is true. I think with high-profile defendants in prison, though, there's always a risk that they could be possibly more targeted, or sort of more attention, negative or positive, is paid on them while they're in jail. Versus, you know, if he's sentenced to home confinement, he has a lot of resources and a lot of wealth still at his readily available hands.
Yep. All right. We had a question from Sean D. Cole on YouTube. Nima, I'll throw this to you. What would be your best possible defense strategy?
Thank God I'm not doing defense work anymore, but I think the best defense strategy would be to argue that the sexual activity happened, but it was consensual. That gets rid of the force, fraud, or coercion. The challenge is if they do supersede and they add sex trafficking of minors, that argument goes out the window because minors can't consent. Now, Diddy is allegedly contacting witnesses, and there's probably a few ways that he can persuade them to either do a 180 or not show up at trial and testify. He can outright bribe them, pay them off through civil settlements and judgments. He can blackmail them. He can try to threaten them. But I mean, his best defense is for these witnesses to go sideways. That's really the only defense in this case.
All right, we have an update from court. Sean Combs' lawyer, Mr. Rico, says the family of Mr. Sean Love Combs are here. They traveled a long way. Judge Subramanian says, thank you for being here. Mr. Agnifilo, tell me about the legal pads. And Mark Agnifilo responds, the first time I saw them was Tuesday. Elizabeth, this feels like in response to the issue that happened earlier this week about whether the government improperly photographed potentially privileged materials of Sean Combs. I didn't think that issue was going to be decided today, or at least discussed today. I thought they were going to be briefing it, and maybe the judge would have to decide if there was a privilege issue later on. Actually, before I throw it to you, another update. As we sit, this is from Mark Agnifilo. As we sit here today, I'm not sure when legal was written on each of them. I'm trying to get to the bottom of it. Different members of the defense team were telling him to write legal on the pads. There's a photo of a pad without legal on it. Again, this is all in relation to whether there was a big sweep at the Metropolitan Detention Center and photographs were taken of Sean Combs' notebooks. And the question was, were 19 pages or other materials improperly photographed of his conversations with his attorneys about legal strategy, what was written on the pads? What do you take away from this?
That's right. So I'm not surprised that the judge is discussing it a little bit. The judge had said earlier this week that he will hold separate hearings regarding whether these notes could be actually ultimately used at trial in May, and that's sort of later on down the line. But he did say in a filing earlier this week, be prepared to talk about what happened with that legal sort of note that was on the papers and where did it go. I'm not surprised that he wants to talk about that, because I think a big part of what the prosecution is going to try to argue to prevent him from being released on bail is potential witness tampering. And what they said earlier this week is that there was some evidence within the notes of him, trying to contact witnesses through third parties, trying to get family members to post, positive things about him on social media. So I think there's a little bit of an overlap there.
And there is certain material that was photographed that will not now be used as evidence in this bail argument. The judge said, throw it out, throw out these copies. You're not going to be able to argue that prosecution to support your case. But Elizabeth does raise an interesting point here, Nima. The idea, and I think this will come up, was Sean Combs developing this social media campaign through his family really is centered around his birthday, to post positive messages about his birthday. There was this video of his family wishing him happy birthday. You can hear him on the other line from the MDC. He seemed to be happy. And the idea was he purposely orchestrated this social media campaign to influence a potential jury. And the idea would be, if he's orchestrating this behind bars, you can't let him out on pretrial release. What else would he do? Now, I'm curious your thoughts on this. Some would say, and the prosecution says we have evidence to prove that was his intent, was to influence a potential jury. Do you think that's strong, though? I mean, we're not even close to a trial. Do you think? And also, he's a public figure. Doesn't he have a right to change the public narrative about what everybody's been saying about him?
Jesse, I'm as pro-prosecution as they come, and I believe that they have evidence that he's contacting witnesses, and that is witness tampering and obstruction. But to argue against a social media public relations campaign is really a bridge too far, in my opinion. If you're the prosecution, you got to kind of maintain your credibility. Obviously, there's the courtroom and there's the court of public opinion. There's no gag order or other order preventing him from doing this. So don't make arguments that not necessarily aren't nonsensical, that aren't really advancing your case. Focus on the witnesses and what matters, and you don't have to worry about Instagram and TikTok and Facebook and whatever.
Well, it was interesting because his son took over his social media account. His Instagram account was posting like music videos of his father and behind-the-scenes footage of his father, and we did a sidebar on what that might mean, and now we see what the prosecution is taking away from some social media posts. Okay, we have an update from court. Nima, I'll just start with you on this. So Sean Combs' lawyer, Mark Agnifilo, said, so it's clear that on November 1st, the sweep, which I had mentioned, the sweep of the MDC, they did not all say legal, meaning it was not printed legal on his Sean Combs notepads. The judge says, the pad you handed up to me, did it say legal on it on November 1st? Agnifilo says, I'm not sure. The judge responds, moving forward, make sure representations are true. Ooh, felt like a little bit accusing the defense of not being totally transparent, right?
I think so, and it's not the first time. Going back to that video from 2016, the defense said that DHS leaked it, and there's really no evidence to support that. And I understand that they're trying to advocate on behalf of your client, but Judge Subramanian, let's be honest, this is a Democratic appointee. He has a civil background, and I'm really surprised he's taking so much time to address this privilege issue. Obviously, the attorney-client privilege is sacred, but we're talking about 20 pages. Judge, take the documents, review them in camera and chambers, and make your decision. Why do you need briefing on this? It's not something that's rocket science. Any young lawyer can determine whether the documents are privileged or not.
We have another update from court. Elizabeth, I'll turn to you on this one. This is from the judge. Ms. Slavic, this is referring to Christine Slavic. She is the AUSA, the Assistant United States Attorney, the prosecutor in this case, one of the prosecutors. Ms. Slavic, what is the status of Mr. Combs' laptop? And then she responds, the laptop for him to review the discovery at the MDC. The idea is to preload the information he's allowed to have at the MDC on the laptop. There is a protective order. Interesting they're talking about this because one of the arguments put forward by Sean Combs' defense team is he doesn't have the adequate resources at the MDC to properly prepare for what is a complicated sex trafficking and racketeering trial. What is this exchange about, you think?
Right. I think they're probably pointing to an issue with privacy. And like you said, him being able to properly be able to put on his defense. If he's someone who's in home detention, he can meet with his attorneys in fair confidence, discuss things more freely. In prison, you're really not afforded those same privacy rights. So I think that's an argument that his team is going to be putting on.
Nima, got a question. This is from Sean D. Cole again on YouTube. Please keep the questions coming if you have a question about this hearing. If you have a question about this case, make sure to submit them now. This is, with this being the presiding judge, meaning Judge Arun Subramanian, is this Sean Combs' last chance for bail? I don't believe so. I believe that he could go to the Second Circuit and had petitioned the Second Circuit, but then put it on pause, waiting for Judge Subramanian to ultimately decide this issue, right?
Yes. So when you appeal, that really removes jurisdiction and the ability of the trial court to make a decision. So obviously the case was transferred to Judge Subramanian, but they had appealed to the Second Circuit, which is the highest court before that appeal. But now what they want is another bite at the apple, see if the judge is going to disagree with the prior magistrate judge and district judge and actually release Combs on bail, which would be very surprising, in my opinion, before they take it up on appeal.
Elizabeth, I'll turn to you on that. Again, the reason we know some of what the defense's arguments are is because I read the brief to the Second Circuit. They asked to put it on, they called it, oh my gosh, I'm forgetting the legal term, abeyance. They put the appeal on abeyance and said, pause it. We're going to go to Judge Subramanian. If he actually grants bail, this is all moot, forget it. But, do you think the Second Circuit would be more amenable to his arguments?
I think it would be a bit more difficult. Obviously, whenever you appeal a case, the appellate judge is really more prone to being guided by former precedent. It doesn't mean that judges don't overturn decisions. They do all the time, but they are more privy to be bound to prior decisions. Here in this instance, this is his third attempt before the hearing today to be released on bail. You have two prior judges who have said no, for various reasons. So I think it would be harder in his appeal process.
All right, talking about the bail, we now have an update on this. So Judge Subramanian says, on the bail application, I don't have to deal with the Bustani case. The defense is saying there are extensive conditions proposed, including 24/7 security. What about the Fox case? Prosecutor responds, there was no RICO charge in that case. The judge said agreed. So now they're going through some of the case law that was debated back and forth between the prosecution and the defense. Nima, I think what's really interesting, one of the arguments put forward, and I think this is, you tell me if it's legitimate or not, the defense is saying, you're just hearing allegations from the prosecution about that he's a danger here. They're relying on the allegations in the indictment. They're saying that he reached out to witnesses and victims. Don't you need to hold a hearing? Shouldn't you call witnesses to prove that? Now, it's not they don't have to prove it beyond a reasonable doubt. They're not trying to say he's guilty of obstruction, but doesn't there have to be more than just taking the government's word for it?
Not necessarily if the judge takes the government's word for it. And, we've talked about Jeffries, but I think the more on-point case, recent case in New York is Sam Bankman-Fried. Here's someone who was granted bond, started contacting witnesses. There was electronic evidence to support that he was reaching out to witnesses and trying to alter and change their testimony. And his bond was revoked, and he was in custody all throughout trial. So I think that's the case. Look, I believe the government that they have evidence that these witnesses are being contacted by Combs or through intermediaries. They're not going to raise these allegations unless they have the receipts to prove it. So hopefully they do so. But I don't think you need a full-blown evidentiary hearing in a case like this, or any bond hearing.
Elizabeth, you would agree with me that there was no reality where Sean Combs believed he was not going to make bail? The reason he was so cooperative with law enforcement, he'd surrendered his passport, said he was going to sell his plane, came to New York to be arrested, hadn't left the country, right? Even though he knew he was going to be arrested. It seemed to me he thought he was legitimately going to make bail, that he would be on house arrest for a year, 2 years till trial happened. I don't think he thought that this would actually be a reality, right?
I agree. And my theory is that all of these steps were taken by his attorneys and by his legal team to hopefully assure that they can show the judge, he's not a flight risk. He's put up this $50 million bond. He's prepared to put his home up for collateral. All of these steps he surrendered to his arrest. So all of these steps to put forward to try to argue this is not someone who's going to flee. He can be trusted with home arrest. So I don't think he anticipated this.
Going to that, Elizabeth, we just have another update from court. Again, we're providing live updates about what is happening in that courtroom, considering there are no cameras there. Trust me, I could go on and on about how much of a mistake I think that is. But the judge says, I want you to address the proposed conditions, meaning the bail conditions. And as we talked about, $50 million bail package, 24/7 home confinement, no internet use, no phone use, limited visitors, visitor logs. Prosecutor says there has to be some level of trust that the defendant will follow him. Here, he will not, meaning not follow the rules. He cannot be trusted. Consider his conduct in custody after the two judges' findings, meaning there were two previous judges, Judge Carter, Judge Tanofsky, who both decided that Sean Combs was not entitled to pretrial release, not entitled to bail. What do you think about that?
Correct. Yeah, that's a really fair point. The two prior judges have denied and said he's not allowed on bail. So when you have those two decisions against you, I think most defendants would say, okay, I need to be extra cautious, make sure I'm following all the rules. I'm not incurring any potential legal troubles moving down the line. There's allegations that, he has contacted parties through third parties. He's made phone calls. So I think there's a substantial amount of information there to show that there is possibility that he could try to tamper with witnesses or obstruct certain evidence.
Nima, one of the arguments put forward by the prosecution was if he is able, if you take the allegations as true, he's able to use other inmates' PAC numbers to make essentially calls to people that are not listed on his contact list. If he's able to use three-way phone calls from jail to have improper communications, what the prosecution says, is there any belief that he wouldn't manipulate a private security team that's supposed to watch him?
Of course, that's working for him as well. And like you said, that's an absolute rule violation. Can't use another inmate's PAC number, can't make three-way calls. And apparently he's doing all this. And when he was out, he contacted a witness dozens of times. So this is all evidence of obstruction. If I'm the government, what I do is I supersede, I add those obstruction charges, not necessarily because I think that's going to add additional time, but I think that's going to be helpful evidence for the jury to hear at trial that Diddy is trying to dissuade these witnesses. That's going to bring all that evidence in.
To show that he's guilty. Why would he be obstructing unless, of course, he thought he couldn't win this on the merits? He's trying to actually obstruct the case, influence witnesses because he knows he's guilty of that. That would be the argument. Elizabeth, we have another update from court. The prosecutor says his attorneys are enabling his flouting of the Bureau of Prisons rules. Consider the labeling of the pads after the fact, meaning they marked it legal after the fact. That's interesting. Even family members, and I said that the idea would be that he's enlisting his family members to create social media campaigns, reach out to people. The judge says, what's your response if Mr. Combs says, even if they don't trust me, there'd be 24/7 security? Prosecutor responds, if he can't comply in a custodial setting, he will not comply if released. What type of security firm? They suggested a co-conspirator, one whose phone was taken only the day before. Didn't know that. That's who the potential security firm is. The second suggestion was a defense investigator in this case. And the prosecutor goes on to say that investigator has been out contacting witnesses. Essentially, they work for him. This would be the defendant buying his way out. The judge said, you've conceded that Bustani's bar does not apply here. You've cited his wealth to release him, so he can't use it. We'll get to that second argument in a second, but if that's true, this is who he was proposing to watch him?
Yeah, it's a fair point. And again, I think if you consider if he's, let's say, confined to his home and home confinement, I think there's even more opportunity for him to be able to utilize the team and the people around him, whoever they're working for, to be able to work within his favor. And also, this is not somebody who's going to be confined to a tiny little studio apartment. He has huge homes, huge estates. There's a lot of room for him to potentially go about continuing possibly the behavior that the prosecution is alleging he's already been doing.
One of the other interesting arguments that I love to talk about here, Nima, and I'm curious if it comes up, prosecutors said there's a two-tiered justice system. Why would it be fair that Sean Combs has the resources and the wealth to turn his home into a private prison, and he should be out waiting trial on sex trafficking and racketeering charges when somebody with lesser means wouldn't be able to do that and they don't get bail? Now, the defense says, wait a second. The only reason we're proposing such an expansive and expensive bail package like this is because of the very problems, the very concerns that the prosecution has. You say it's his wealth that's a concern. Well, we're going to show you, we're going to create such a package that alleviates any of those concerns. The reason it looks like this, and it's so expansive and includes 24/7 monitoring and all this, is because of what the prosecution said. You can't have a sword and a shield at the same time. You say he's wealthy, you say he has the resources to flee, to do what he wants. Well, we're going to use that to try to negate those concerns. Where do you stand with that, Nima?
Well, it's not a flight issue, but a danger issue, and no other defendant, and I don't think the Jeffries case is similar, would be released with these types of allegations. If we did, we'd be treating celebrities or folks with hundreds of millions of dollars differently because of their wealth. So I think that's a very strong argument for the government.
We have another back and forth that I want to tell you about. It's almost like the judge is listening to our back and forth, because this is what just happened. And by the way, I really, from a legal point of view, I really am respecting Judge Subramanian. He's challenging both sides appropriately here. This is what he says, Elizabeth, the AUSA, Slavic, the prosecutor says, we're not seeking his continued detention based on his wealth, but rather danger, risk of flight, and obstruction. The judge says, is obstruction your main argument? The prosecutor says, danger to others. So the judge says, so not risk of flight? And the prosecutor says, we still rely on that too. What did you make of that?
I think it's important that they don't forfeit any of the arguments, and I think they're all equally important. I do think, I'm glad that they've highlighted the danger issue. Again, so much of this comes back to that video of him and Cassie Ventura. He has assaulted her on that video. He later admitted to that. So that's something that prosecution can point to and say, look, there's a possibility that could happen to other people as well. It's right here in black and white on video. So I think that's one of the more strong arguments. But I think it's important that the prosecution doesn't forfeit any of the other arguments, including obstruction of justice, so that they can put on a fair trial.
Nima, that risk of flight is interesting because the prosecutors say he's facing 15 years to life in prison on these charges. He has a lot of incentive to flee. His response would be, first of all, my family, my livelihood is here. I'm not going to flee the country. I've been trying to sell my plane. I gave up my passport. I could have fled multiple times. I didn't. You think the risk of flight it works more for Sean Combs or the prosecutors?
I don't think it's a very strong argument for the prosecution. This is a style issue, right? Credibility is really important. And when the defense writes illegal on a pad after the fact, that's a problem. And if you're the prosecution, you want to save face. And if this is someone who's surrendered passports, has been willing to sell his private jets, his family's here, I don't think the risk of flight is a very good argument compared to the obstruction and the danger. I don't think arguments, so I would focus on those two. And obviously, you don't want to concede anything, but really just focus on, because you only need one to win, right? And I think the danger is the strongest argument.
You mean you only need to convince the judge whether it's obstruction or risk of flight or danger? You don't need all three?
Generally, it's going to be danger or risk of flight, but the obstruction is important as well. So the standard is under federal law that detention is appropriate if there's no condition or combination of conditions that can guarantee the defendant's appearance at trial, and he or she is either a risk of flight or a danger to the community. Now, obstruction can come in as well, but it's typically danger.
Elizabeth, we have another update from court talking about obstruction. The judge says, tell me about obstruction. Is he listening to Law and Crime? Is there like something, does he have a microphone here or something? Tell me about obstruction. So he asks, he says, tell me about obstruction, prosecutor. Prosecutor Slavic says, he's continuing violation of the rules, meaning, as we talked about, what's happening or allegedly happening in jail. The judge says, is running a PR campaign obstruction? Meaning the social media posts. The prosecutor says that's not what we have here. Rather, it's his concerted effort to impact the integrity of these proceedings. Prosecutor says, he says, I want to reach the jurors. I need only one. Ah, so that's so interesting. That's the first time that we actually maybe heard, they said they would have evidence to prove that this social media campaign was about influencing the jury. So he allegedly, there's some communication from Sean Combs where he talks about, I only need one, meaning only need to convince one juror. The judge says he's not permitted to engage in any he's not permitted to engage in any conduct to impact the jury pool. That's what the judge is asking. Prosecutor says his intent, it's obstructive conduct. He's violated the so-called gag order. He's the one who asked for that order.
Right. I think the social media argument is a bit of a tough one to make. Again, as we've noted, he's a massive public figure. People have continued to post on social media about this, people in his family and his friends. So I think that's a bit of a reach. But I think it's important that the prosecution highlights, again, any sort of evidence where he specifically states, I'm trying to target potential jurors here. He might have said that with social media, a little bit tougher. But I think the stronger points lie in if there's any sort of evidence that says he's trying to potentially contact witnesses through third parties to what prosecution is claiming, alter their testimony, give sort of more favorable testimony. I think that's what's going to be more persuasive to the
By the way, that gag order, I thought that was about not releasing grand jury materials or information that hasn't been disclosed to the public. I mean, if you're posting about your birthday, you're posting your music videos, I don't feel that the gag order applies, no?
I don't think so either. Again, unless they're commenting on something specific regarding the alleged details of this case or the indictment or anything like that. I think general content posted on social media, I think it's expected even in cases involving more private figures, let alone someone this public.
Nima, do you agree about the gag order?
I agree. It's not within the limitations of the order. And again, this is just not a good argument for the prosecution. I agree that him trying to influence jurors, that is, but just generally a blanket argument against a PR campaign and social media post, not good. No judge in this country is going to prohibit someone from posting on social media. Just so let's be honest, this is the biggest trial in the country right now, especially now that Donald Trump has won and his criminal problems have gone away. Nothing even compares to the Sean Diddy Combs trial. People are going to be talking about it. Everyone is covering it. Traditional social media. I've done dozens of interviews just on Law and Crime about it. So for a judge to say that you can't post on social media about your birthday with your family, I mean, forget about it. That doesn't make any sense whatsoever. No appellate court would uphold that order.
Clearly, you do not believe that Kanye West being sued for copyright infringement is the bigger case, and that's shocking. I didn't expect that from you. Okay, we have another update from court. This is from the prosecutor. The court entered the order on October 25th. He started his campaign on October 27th. He couldn't even comply for 2 days. The judge said, what about the, we have something. What about the Jeffries Abercrombie case where the government agreed to release on $10 million bond? And then the prosecutor says, we did a letter, and by the way, that's the letter that we read before, where basically the government talked about distinguishing Mike Jeffries. It's not only his age, we're talking about the idea that he's not charged with sex trafficking. There was not these repeated patterns of violence like they allege with Sean Combs. And so, again, now it seems like they're getting into that issue, which I think is going to be really, really important. Again, just for our viewers turning in, Elizabeth, you see that the case of Mike Jeffries, who has been arrested and charged with sex trafficking of young men using force, fraud, and coercion. That is a slightly different case because he was granted $10 million bail. He was arrested after Sean Combs was arrested. But that is a different case that you think prosecutors might have a struggle with.
That's right. I think there's some overlap. Again, it's involving massive public figures, it's involving trafficking charges, but I think there's a big difference, in terms of the racketeering charges, the amount of civil lawsuits. Again, they're alleged civil lawsuits, but against Sean Combs, there's currently over 100 with similar charges. I haven't seen anything similar to that extent of Jeffries. And also, again, it keeps coming back to that video. There hasn't been any form of video evidence, at least that we've seen in the public domain. Correct. Yeah, with the Jeffries case that specifically highlights what a danger he could possibly be to the public. Again, at least that we know of yet.
So we're going to go back to more questions that we have from our YouTubers. So if anybody has a question about the case or the hearing, make sure to submit it. Nima, we have a question. This is from Sean D. Cole. Sean D. Cole, so active. Thank you so much. Does the defense argument for bail convince you that he should be granted bail, Nima?
Sean, absolutely not. Sean Diddy Combs should not be released. He is a danger to the community. The allegations are very serious. He probably will be convicted and will spend decades in federal prison. This is a very serious case with a lot of victims. He should not be released.
Here's the thing, and by the way, you'll see this anytime you hear appellate arguments or even if you hear general arguments in a court of law. The judge will ask pointed questions from each side when he's questioning them, okay? So I want to be clear, even though you're seeing tough questions for the prosecution, doesn't necessarily mean he's going to side with the defense and vice versa. Having said this, I'm going to read you the latest from court. The judge, the prosecutor, they're talking now about the 2016 video of Cassandra Ventura, or I believe that's what they're talking about. Because the prosecutor says, I think the better comparison is the two prior denials of bail here, but the judge said, what about the claim that the government spliced the video? Prosecutor said he apologized. That's the point. Remember, Sean Combs apologized on Instagram 2 days after CNN published that video of him purportedly beating Cassandra Ventura back in 2016. The judge said, why did you use the splice video, not the original? And the prosecutor said, it was public. So it makes me wonder, is he open to the argument that there's more context to that video, as the defense says?
Possibly. To me, it sounds like the judge is asking a bit more open-ended questions to get all the information that he can to properly render a decision about this bail hearing. I think if there's any sort of indication that that video of him and Cassandra Ventura in that hotel hallway was doctored in any way or edited, you still have the actual footage of him assaulting her. And again, as you mentioned, he didn't negate that. He didn't say, oh, this is AI or this is fake. He admitted to that. So I think what the defense team is trying to use is there's no indication that she tried to flee a freak off. I think one of the things his defense team called it was a sad glimpse in a consensual relationship, which I think is going to be their main theme in defending this case, is these were all consensual acts. So I think he's just trying to get information here. I think it's hard to negate the facts of that video.
So, Nima, I'll give you a chance to respond, but here's another update. The cell phone footage, this is from the prosecutor. The cell phone footage was grand jury material, and we didn't want the defendant to be able to retaliate against the grand jury witness. We did add blurring of the victim's face. In 2016, the defendant bribed hotel security $100,000 to make it go away. Your thoughts on what we're hearing about this?
Yeah, I'm shaking my head because this is not edited. This is why this is important. First of all, we know that Sean Combs paid $50,000 or $100,000. I've heard both numbers. Apparently $100,000 to try to keep this video. Now, in November, Cassie files her lawsuit. Combs, through his attorney, says that this is all these are lies. This is all fabrication. This is a money grab. His homes are raided in March. Again, still denies everything. Only after CNN gets this video in May does Combs finally admit to lying for 6 months through his attorney. So he can't be trusted. Here's someone who's denied everything, but you can't deny this video. That's why his apology is important.
How much does it matter, Elizabeth, that this could be connected to a freak-off or sex trafficking, or does it matter that it's just a violent episode? Because, the latest update from court, the prosecutor says, does it matter if he threw a vase or the contents of a vase? He admitted to it and apologized for it. This took place in the middle of a freak-off. The U.S. has evidence a male commercial sex worker was in the hotel room at the time. So they're really trying to say this is evidence of sex trafficking.
Yeah, I think that's important. I think that's going to be important for the prosecution to say, she wasn't just fleeing for any reason. It was specifically to flee a freak off. Because again, one of the things that the defense is going to try to push is that they were in the middle of a consensual act. Regardless, I think you also have one of the things that was mentioned in the indictment was the multiple assaults that he allegedly inflicted upon women. This is clear evidence of that.
We have more questions from our YouTubers, the best YouTubers in the business. All right, Nima. This is a question from Sally on YouTube. Once Diddy finally goes to trial, how long do you think the full trial will last?
I think it's going to last about a month or so. I mean, the parties have given some estimates, about 3 weeks, I believe, for the prosecution and 1 week for the defense, if I recall correctly. That means I think the defense's case is entirely or mostly going to be based on the cross-examination of those witnesses. They're going to come after them very aggressively. Now, it's still pretty early to know who exactly the government's going to call. And that's important because you have individuals who have filed civil lawsuits. They're going to be cross-examined to say, this isn't about criminal justice. This is about money. So I'm sure the government is going to want to put their very best witnesses and victims on the stand because we know that the defense is going to come after them and come after them very aggressively.
All right, we have another update from court. This is from the prosecutor. This is devastating evidence for the trial. This is, again, the 2016 video. It shows why he cannot be released on bail. He is violent and is committed to covering up his...
Is trying to give a real fair analysis to all this. And this is a collision between First Amendment rights, as far as I'm concerned, and some of the requirements under bail, if there should be bail given. You're not supposed to have contact with witnesses. You're certainly not supposed to intimidate witnesses, but you're also able to defend yourself and marshal a defense and speak your mind as a defendant. And judges always have a very difficult time trying to balance those two constitutional issues. And I think this judge is struggling with it because this is a man who's on trial for his life. His liberty's been taken away from him, and he's fighting back. And that would be something that one would expect of someone who's been accused of heinous crime. So I think that today is probably, as I think you've described it, really the first opportunity for there to be a healthy debate on why he should be released.
And Bradford, I want to give you an opportunity to respond to that as well. I do want to let you know there was another update where Ms. Garagos, who again is one of Sean Combs' attorneys, says, my client obeys me. For example, on victim 3, he stopped using ASAP and other phone lines. The messages with witness 1 were pre-arrest. He obeys us. He came to New York. In the Bureau of Prisons, when I tell him not to do something, he does it. So in other words, if you have concerns about him flouting the rules, he will listen to us. We'll tell him what to do. What do you think?
I think that's an argument that I've often made, and I think a lot of defense attorneys make in terms of that our clients will listen to us if we tell them what to do and what not to do. And in certain circumstances, you have clients that have not been in a situation like this before where they're in custody, where they are getting a barrage of allegations against them. Some may have some basis of truth and some may not. And you've seen that over and over again in this case. There have been reports of different things that went on and different allegations against Sean Combs that they have then found out, these are just rumors and they're not true. I think that it's not a bad thing when a PR company or even when a defendant takes it on himself to have family members talk about the good thing that he's done in the past and the charitable things that they've done in the past. When you have a case like this, where they are just every day, there's something that is coming out, something that is leaked by either the government or a party that's involved or someone that's interested in the case, where it is affecting, that could have affected a jury. I think that, that release of that Cassie tape, and I keep going back to that release of that Cassie tape, I think the tape was released because they knew that she was going to be somewhat blamed for the behavior that happened, that they would know that she would participate in these different things with different individuals, and they wanted to make sure that was cut off at the pass and essentially make her a victim and not a co-defendant. And I think that's why that tape was eventually leaked by whatever party that leaked that tape. a lot of not going back to that. No one's really discussed how that tape has come out, and I think it's an interesting thing. And especially when you have a judge that's interested in your story, and you have a prosecution that is interested in why he is making these, these PR moves on social media. I think it all comes back to that tape, and I think that's their strongest, quote unquote, strongest piece of evidence in terms of their star witness to say, hey, this guy's a bad guy. I do like the fact, and I will agree with Brian, that the fact that they're having a conversation, that the judge is engaging them, is always a good sign. Is it, the end all be all that he's going to grant him bond? I don't know. I think this is a tough hill to take. I think it's an uphill battle whenever you have an individual that's facing the type of time that they're facing and the type of allegations to get a bond. Certainly the bond package is pretty extensive in my opinion. A $50 million bond is nothing to sneeze about.
And to go into that, about one of the areas where I think Judge Subramanian seems to be receptive. He actually told prosecutors early this week, be prepared to talk about this. It's coming up right now, and Brian, I'll ask you about this. So this, Ms. Shapiro, who's Sean Combs' lawyer, says, I submit the charges in the Jeffries Abercrombie case are worse than here. They allege an international sex trafficking business. They were raped and forced to engage, and I'm not going to say, but in a certain kind of sex acts. And by the way, the argument here is, and this is what the Judge Subramanian said, is distinguish prosecution why it is Sean Combs, after putting forward a bail package, as we said, $50 million, 24/7 private security firm, limited visitors, visitor logs, no internet use, no phone use. Why is he denied bond when you have Mike Jeffries, the former head of Abercrombie & Fitch, who was just arrested and charged with sex trafficking? Why is he out on $10 million bail? And by the way, the prosecution responded earlier, and they had a back and forth about this. He's 80 years old. Sean Combs is 55 years old. Sean Combs is charged with racketeering. He's not charged with racketeering. Sean Combs has alleged instances of prior violent behavior, not the instance with Mike Jeffries. But here you're seeing, Brian, where they're saying, we actually think the Jeffries case is worse. What do you make of that?
Well, it's brilliant. And I think that's the road they have to travel because it's precedent. You're not supposed to have different rulings for like-minded cases. Disparity in treatment is always frowned upon in the federal courts. And here they have a significant public interest case where bail was set at $10 million by agreement. It wasn't debated over. The government agreed to it. Now we come over to Sean Puffy Combs' case, and they're objecting to 5 times that amount for someone who I don't believe has ever been convicted of a federal crime or a felony. I could be wrong about that. And they're putting restraints in place that make the previous bail package pale in comparison. So they're right to make this argument. It's precedent. It's precedent within that jurisdiction. And I think the judge is going to look hard at it. You've now got 2 rulings that have gone against him. So he's got to look at those rulings and those judges. But he's also got a situation where the government has agreed to bail in a situation that's, if it's not as bad, it's pretty darn close by accusation.
Mm-hmm. And look, I think they could, look, it's also a different court. This is a different, this is the Southern District of New York. That was the Eastern District of New York. But even you put that difference aside, this seems to be one of the more compelling arguments put forward by the defense. Bradford, we're also taking questions, by the way. So anybody who has questions about this case, submit them on YouTube. If you have questions about the hearing, submit them. We have this interesting question from Sahara Useri on YouTube. Why did Combs get a new judge to begin with? It's interesting, right? Because I believe we had a district court judge or a magistrate judge, then a district court judge, now Judge Arun Subramanian. Why do you see a reassignment of a case like this? Why is it now in the hands of Judge Arun Subramanian? Why do you see this happen, Bradford?
Well, on federal cases, we always appear to begin with in front of a magistrate. That's usually the first person who hears the case, if it's a bond issue and or if it's even a preliminary issue. A lot of times court judges will give magistrates the power to rule over different kind of motions to suppress, and motions to dismiss. But we always go in front of a magistrate that's associated with the judge, and then generally you then go to the judge that's going to have your case. It just depends. Sometimes you go to a temporary judge until it gets assigned. A lot of times judges don't have time for the type of case that it is, or they might not have the schedule that will behoove a trial in a certain period of time. I believe that this trial is being set for April, and it might be the other judge that was assigned already has a case that's set for April. That's not uncommon. I don't see that as like unusual. We've seen that in many cases. I've had many cases where judges have changed at the beginning of the case. It's usually unlikely that at the end of the case that you have a judge that'll change once they've heard motions and once you've done discovery and things of that nature. But I don't find anything of that unusual. Magistrates are always common. You always go in front of a magistrate first, and those are usually randomly assigned. And then a judge is randomly assigned, and then another judge can take over at any time. It's not that big of a deal.
And by the way, I wish we had cameras in the courtroom, but based purely on the arguments that we're seeing and have seen with Judge Subramanian, I feel confident to say this feels like a very fair, well-reasoned judge. The way he was pressing the prosecution, the way he's been pressing the defense, it's really something to take note of. And that's kind of the judge that's exactly the kind of judge you want in these cases. There's a question that we have from Samian on YouTube. I'm curious, Jesse, why did the prosecutor not reference the R. Kelly trial? They might not have referenced it today, but it was in their filings. I think it was even in the very first bail filing. They referenced the R. Kelly case. They referenced the Jeffrey Epstein cases as why it would justify bail for Sean Combs. Here's another question. I'll throw this over to you, Brian, from Europes Hunar on YouTube. If Diddy gets out of bail, does that mean that he gets out immediately, like this hour?
It'll happen pretty quickly. He'll have to go back. Usually you have to go back to the detention center that you're being housed in. There's some paperwork that has to be done, but I would think it would happen pretty quickly. It would be tonight. Unless there's some other snafu that occurs in trying to get it done. But for a high-profile case like this, they'll move quickly on it. All the eyes of the world are watching it. I think it'll happen pretty quickly. It'll certainly happen, I think, sometime tonight, if he rules tonight. I mean, that's, some judges recognizing that there could be an appeal of this ruling will take the time to issue a written opinion. And that would be the only reason I would think this judge would hesitate before ruling in this case. He seems, as you've described it, to be a really fair-minded and thoughtful guy. That is his reputation. And some of those judges that are more thoughtful and more fair-minded issue written opinions, which he may do in this case.
We have another update from court. Ms. Shapiro, again, defense counsel for Sean Combs. While in Jeffrey's case, one defendant is 80 and the other is 71, Mr. Combs is 55. I hate to say it, it's not that young, because that was one of the things the prosecution said. Like, you're
Objection.
dealing with an 80-year-old. Yeah, you're dealing with an 80-year-old. You're dealing with an 80-year-old. He's 55. He's much younger. He's more of a danger. The judge says the U.S. suggests he won't follow conditions. Shapiro says these conditions are more restrictive than in the prison. Again, I kind of laid out what some of the conditions are. Bradford, your thoughts?
I think the argument that one guy's 80 and one guy's 55 is, if I was a judge, I think that would fall on deaf ears. The 80-year-old might be more willing to do something crazy because he's 80. It's like he only has so much time left. Anytime you give an 80-year-old is going to be a life sentence. So if the guy gets 5 years and he's 85 years old, that's not that young. So the argument itself is not great about the age. I think the stronger argument is maybe that in the RICO charges, they're charging some sort of violent behavior. That's probably a stronger argument because the Abercrombie and Fitch CEO doesn't have a history of alleged violence or participation in violence. But the allegations of the sex trafficking are very, very, in my opinion, are worse for the CEO of Abercrombie and Fitch. And it's just, it's funny that it just by happenstance, these cases happen together. If it didn't happen together, you'd have nothing to compare it to. You'd have to go back to a different sex trafficking case that someone didn't get bond. So it just so happened that this worked out for Sean Combs where the Eastern District comes to an agreement on the CEO of Abercrombie and Fitch and it works in his favor. I think that you have to lean very heavily on this guy could make a run for it at any time, right? It's not just that he's a danger, it's also that he's a flight risk, they were arguing. He could have made a run for it at any time. He has jets. He could have gone to Mexico. He could have gone anywhere, and he never did. He surrendered when he was supposed to surrender. In fact, they didn't even allow him to surrender. They picked him up at night at a hotel when they knew that they could have called him and he would have just surrendered in the morning. I think that it goes to show a lot of bias, obviously, on behalf of the U.S. Attorney's Office. And I think a judge like this judge, who used to be a clerk for really, really good judges and was in the commercial business world and kind of looks at things that way and looks at objectivity that way, I think was a real, real good thing for Sean Combs here, because a lot of other judges that have been kind of jaded by the criminal system might not give him as fair of a shake as this judge is. And this judge is fairly new to the bench, so I think that benefits Sean Combs as well.
It's interesting you say that, because I want to read you the latest from court right now. So the judge says, Mr. Agnifilo, where is the home he'd be in? So again, if you're talking about home confinement, Agnifilo says, I don't want to give the address, but it's on Star Island. There's a causeway. This is in Florida. This is Miami. There's a dock, but there would be no boat. The judge responds, that's not going to work. We're in New York. Agnifilo says, give me a moment. He comes back and he says, there is an apartment on the Upper East Side. We have one available, 3 bedrooms. The judge says, where are the 24/7 security going to be? Agnifilo says, would you like to speak to him or me? It's Patriot Security. They merged with Crisis 24. So, Brian, now, is this just the judge doing his full due diligence about understanding what bail would look like, or is this kind of potentially a sign of where he might be going? And by the way, we have another update. He says, Agnifilo says there'd be 2 security guards in the apartment and 1 downstairs, so a total of 3. No access to phones or the internet except for calls with counsel arranged by the security personnel. This is more restrictive than in the MDC. Brian.
I think he's leaning toward letting them out. The response to the judge, by the way, about jurisdiction is crucial. Most courts, no matter where you are, if they're going to release you, they're going to release you to that district. And so I was kind of surprised that the bail package didn't originally provide for that, because no one's going to let him go to Florida. But I think this judge is giving real serious consideration to letting him out. Think about it. All the headaches go away. We don't got to worry about the FDC. We don't got to worry about what's happening at the FDC. We don't have to worry about counsel complaining about the fact for the next 9 months that they don't have true access to discovery, that the defendant doesn't get discovery, that the defendant doesn't have the opportunity to defend himself with counsel. All those issues go away for you as a judge. He's not running anywhere. And if they're right, and he's foolish enough to engage in threatening behavior while he's out on bail, that will be the first piece of evidence they introduce at his trial. So I think the judge is a pretty smart guy, and I think he well realizes that the original bail package probably should have been something that they gave serious consideration to. You know, he's presumed innocent. You know, the presumption of innocence all of a sudden fades away when we talk about celebrities. But he's presumed innocent in this case, and bail is for people that are presumed innocent, and he is.
And from the prosecution's point of view, you know, in one hand, if he is let out, engages in obstruction, they can not only have the bond revoked, but gives them more evidence for potentially a superseding indictment, more evidence for at a trial. But the downside is they don't want to be in a position where witnesses are threatened or intimidated and don't cooperate with the government. So it's kind of a tricky situation here. We have an update here. Bradford, I'll go to you. Agnifilo says, Mr. Combs would avoid all contact with anyone who may be a witness. I think he has a right to do that, but I want to make it as easy for the court as possible. We are going to investigate thoroughly before the May 5th trial. He has a right to assist. Your thoughts?
I think that, like I said before, I think that, you know, every argument that they're making is falling on ears that are open instead of deaf ears. Whenever you're a defense attorney, and Brian knows this as well as I do, and you're representing a high-profile individual, sometimes there are preconceived notions, and the judge has kind of already made up their mind while you're arguing, and you can see it in their face. They might give you a what seems to be a fair shake, but ultimately they have made up their mind. In this case, as the argument is progressing and his attorneys are adding on to the bail package that he's not going to have any contact with anybody, he's not going to have any phones. And a lot of times when I have clients, high profile clients in federal or state court, and I offer 24-hour security, I usually hire ex FBI, ex DEA, and I'm sure the company that he has is probably along those same lines that give credibility to the security that's going to be watching him and making sure who's checking in and who's signing out and things of that nature. All those things add up in a judge's mind to assure them that they're doing everything possible to kind of stay out of the way and not get in trouble. I honestly do think, listening to what's going on, the judge is giving serious consideration to allowing him out on bond, which to me is a surprise, because a lot of times in federal court, you don't get that fair shake. When you have these allegations and you're representing someone who's high profile, a lot of times these judges have made up their minds. I mean, we want to feel like every judge is fair. We want to feel that the judicial system is fair, but a lot of times that the judges have already made up their minds, and it's very difficult to get a bond on this case. And I think that his defense attorneys are doing an excellent job in putting together this bail package and explaining it to the judge, and coming up on, and often you find yourself doing this, coming up on the fly, where the judge says, hey, that's not going to work. Florida's not going to work. I need something else. And it's like, yeah, I got an apartment on, the Upper East Side. It's a 3-bedroom apartment. We're going to put him in. That's not easy to do. And it is a hats off to his defense for coming up with those things on the fly and being able to modify their argument that way. And I honestly think when a judge starts asking questions like that, he's very strongly leaning towards granting a bond.
Well, it's good when you're a multimillionaire. You could just, where am I? Where's this case happening? Yeah, I got a property around the corner. Let me ask you this. So this was brought out by the prosecutors earlier on, where they said, okay, want to talk about the security team? So they say, because the judge asked, what are we talking about? They said, what type of security team? He's suggesting a co-conspirator, one whose phone was taken only the day before. The second suggestion, was a defense investigator in this case. That investigator has been out contacting witnesses. Essentially, they work for him. So the reason I bring that up is because the judge just said the government is saying Mr. Combs would be paying these people. It comes down to trust. Mark Agnifilo, again, Sean Combs' defense counsel, says it's a different relationship. There are professionals that are only going to be in his life for 8 months. It's a high-profile case. He goes on to say he's been in jail 66 days without a laptop. He only got one a few hours ago. What is unique here is to have waited 9 weeks to get a laptop into the MDC. The judge says the solution is for you to come to me. We can call these hearings, which get things done. Okay, so that's a separate issue about what the resources he has. The question, of course, Brian, is can you trust the security team? Prosecutors say, A, they have the connections to him, but B, even if they didn't, he has a way to compromise people. If he's in prison, if he's in jail right now at the MDC and he's using inmates' PAC numbers to make phone calls, that's the question. Can we trust the security team? What do you make of that?
As my brilliant colleague just pointed out, the way to go would be to make sure that you've explained to the court that you've got a team that is beyond reproach. And I'd be a little stunned if that's not the case. They should have former FBI, former New York police, somebody that when the judge hears their bona fides, he's going to say, you know what, this is somebody who's got some intellectual honesty. This is somebody who's not going to risk their reputation for a payday. And so I would expect that if the judge does release him, he's going to want to see that. He's not going to want just somebody on this guy's payroll to be overseeing him, during these 9 months, I can assure you. So I'm surprised if that's not the case.
Right.
And knowing Mark, as I do, who's a preeminent lawyer, they'll make sure it is the case. If they've already provided a team, they'll get a better team. If that's an issue with the judge.
Let me ask you this, Brian.
And Jesse.
I'll ask you both this, because this is a question that we got from one of our YouTubers, Floss Daly, Who pays the security company? If Diddy's paying it, is that a conflict? I'll allow either one of you to address that. If Bradford, you want to address that? Yeah.
Sure, yeah, because I was going to add in, it's an absolutely great question. And what I do is to kind of take out the stench of any kind of impropriety that you think could go on. I figure out, okay, if it's 24-hour security for 8 months, it's going to be 250,000, 350,000, whatever it's going to be. And I instruct my client that we put that money in my trust account, and that or a company is hired to pay them separately from just the defendant, or ADP, or they're going to get the paycheck from my law firm, but they're not going to be relying on the defendant to get paid, and they can't be threatened like, hey, you're not getting a paycheck unless you let me use your phone. A lot of times that also helps in these situations where a judge is asking about, how is this going to work with this 24-hour security? And they're going to be behooving to him because he's the one who's paying it. I think it takes out one of those links, and it also benefits the court's decision. It eases their mind on that issue.
Brian, I'll give you an opportunity to respond to that, but we also have another update from court. Mark Agnifilo says, I have a whole presentation ready about the tape, but if you've got enough, I can save everyone 15 minutes. The judge says, I have reviewed it. Who is here from pretrial services? Pretrial services comes forward and says, we maintain conditions are insufficient. The judge says, have there been other cases with private guards? Pretrial services says, not that I'm aware. What do you think, Brian?
Happens all the time. Pretrial services, they do a great job, but, they're a government entity. And in a case like this, the default position always for pretrial is going to be detain. It's easier for them to do that. This judge knows that. One of the other things that came to mind while I was listening to Bradford was, I wonder if the government didn't do themselves a disservice by this untimely search of the cell.
Yeah.
Where they shook his cell down. They allegedly looked at privileged materials. That's a no-no. And I don't think this judge was all too pleased with it. And I think he started doing the math in this case and started thinking to himself, it may be easier for everybody, including the government and the prison officials, if we let this guy pay a lot of money for a private security firm to keep him from fleeing, and we'll get this case tried in a timely fashion. I won't be running into court every week or two with a complaint about discovery. He didn't get his computer. We've got so many terabytes to go over. We don't have the ability to defend. It puts so many issues into a case that can be easily resolved with agreeing to the bail package. So it was just another thought.
And
yeah, Brian's
Bradford,
100%
yeah,
correct.
Bradford, jump in on that. Yeah.
Yeah, he's 100% correct. So first of all, there's been cases in New York. I've had cases in New York where we've recommended private security and got granted private security. And around the country, when you look at these high-profile cases, there's been many, many cases where private security. One of them is an NBA YoungBoy who had a case in Louisiana. He had private security as part of his bail package in Utah. Kodak, who I represented, he had a private security as part of his bail package. It's happened many, many times. And I think the number one takeaway that Brian is so right on is that this searching of his jail cell was so very stupid by the government, and they just can't help themselves. Like it's really sometimes, they can't help themselves. Even when they have cases that they feel are good, they want more.
Just to be fair, they said this sweep of the MDC was it was comprehensive. It wasn't just aimed at Sean Combs. His defense team says it was a pretext, but just to give you the other argument.
I have a very cheap bridge for sale for you. Listen, I think that this was I think he was a target. I find it very hard to believe that it wasn't. You had a specialist that was there that normally is not there. He's taking pictures of items that have nothing to do with what they're searching for, phones and drugs and things of that nature. I find that very hard to believe, and it just is shocking sometimes when you look at the government when they have so much power. They have so many assets that they can use to obtain guilty verdicts, and they want more. They always want more. And in this case, I think this bit them in the behind. I think that the only reason this judge is being so not, I don't want to say he's being so reasonable. The only reason that this judge has considered some of these arguments, I think, and they're not falling on deaf ears, is partly because of the prosecution's dream that this was just, oh, this was something that was going to happen, and we didn't mean to get his notes. And even though we had his notes, we had a team, we put up a Chinese wall. They have every excuse in the book, but once you taint a case with something like that, it's very hard to regain a judge's trust. And I think that's why a lot of these questions are being asked of the prosecution. And in addition to this guy who got out, the CEO of Abercrombie and Fitch, I just think a lot of things came together for Sean Combs to give him this opportunity, and this is his best shot.
So we have another update from court where the prosecutor has now jumped in and said, consider witness one a participant in multiple freak-offs. Defendant continued to contact witness one after counsel was retained. The Instagram post was planned for a week using Contact Me ASAP and other inmates' codes. Really, really interesting there about that, basically suggesting that Sean Combs is engaging in obstruction. I wanted to ask you, we have a question from one of our viewers that I think is fascinating. And Brian, I'll throw it to you. Are there any additional bail conditions the judge could impose on Sean Combs? Could the judge place Sean Combs under the supervision of the Federal Probation Office?
You know, I have never seen that being done. I mean, anything that the probation office could do would pale in comparison to what the defense has already submitted. You put somebody on a bracelet. I mean, they don't have the resources to have 24/7 guards in the U.S. Probation Department. More importantly, that's not their role. So, fair question. Why not have the feds protect him and police him while he's out? It's not the way the system works. And more importantly, I think to all of this is, there has to be an ability for somebody to defend themselves. And what the prosecuting team seems to be relying on here is his efforts to really defend himself. He is looking for help. He is looking to try to line up witnesses, to marshal a defense, to reach out to allies, to get friends and family to get on social media so he can start not winning the battle, but just try and making the landscape a little bit easier and more even. And so I don't know what this judge is going to do, but I would tell you constitutionally and legally, the easy thing to do would be to allow this bail package to be put in place. And the worst thing that could happen for the defendant would be if he spit in the face of the court once the court gave this to him.
Yeah. And by the way, that brings me to another point. So Bradford, we have an update from court. The question becomes what he was allegedly doing while at the MDC. We can have a back and forth about whether or not he was actually engaging in obstruction and what the contents of his messages were, versus was he just violating the Bureau of Prison rules. If they tell him not to make a phone call or they tell him not to do this, whatever the contents of it were, if he violates the rules, the idea is he violates the rules of the Bureau of Prison. What makes you think he won't violate the rules of his bail? The reason I say that is because the prosecutor said his family member said the lawyers say not to do it, and the defendant responds, "I don't care, it's my birthday." This is in regards presumably to that whole social media campaign about surrounding his birthday and the birthday video. So the idea would be he just didn't care, he violated the BOP rules. The judge said, Ms. Shapiro said sharing codes is common with other inmates and the conduct was covered by the First Amendment. The prosecutor says, the Bureau of Prisons handbook prohibits this. So it becomes a question, the content of what he was doing, Bradford, versus did he just straight up break the rules? And if he just straight up broke the rules, is that a concern for why he shouldn't be granted bail?
So the rules that he broke are broken on the daily basis. Like it's so idiotic when they just overshoot every time and say like, oh, it's three-way calling. He broke the rules. I don't even know how many times. I'm sure Brian has been through the same thing. I don't know how many times our clients call us with three-way calls and using someone else's PIN. And it's not that they want to discuss anything. It's all attorney-client privilege when they call us, unless it's a three-way call and there's someone else on the line, then it's not. Different issues with bond and how
get snow up there? I got snow last night. About 2 inches.